It is always best for the children if parents can continue to get along after a divorce. Children are generally very resilient. They can get over things, but if there is continuing conflict between the parents, there is continuing stress, tension, anxiety that's going to be visited upon the child or children.
Perhaps you and the other person can settle your differences without outside help, but if not, there are ways to reach an agreement without going to trial. You can participate in mediation or a settlement conference.
Parents should also understand this. Courts, we are very bad at bringing up children. We're not equipped to do that. I can make rules for parents to follow, but then everybody's lives always change over time. So you come back, we do it again. And at each time you go through an adversarial process, you're going to push parents further apart. And then the children get lost in the middle. So basically, I fully encourage, I would like all parents at least to explore the option of mediation.
When you file your case with the court, the case will go to the judge for trial. You have other options than turning over the decision-making to the judge. There's what's called mediation. Mediation is a process where you and the other side can sit down together with the help of someone to come to an agreement. You can agree on some of the issues in the case or all of the issues in the case. Any issues you agree to will become a court order. In mediation, a third neutral person, not a judge, will help the two people resolve the issues in their case. Mediation is voluntary, informal, and confidential. The two people in the case create their own solutions by discussing different options. The mediator does not make decisions. He or she facilitates the discussion. The mediator helps to figure out the issues that are important to each person, explain and understand each other's needs, clear up misunderstandings, explore creative solutions, reach acceptable agreements. Just about any disagreement can be mediated if the people involved are open to discussing things. Mediation can be a good tool in putting together parenting plans and in dividing property and debt. Many people decide to try mediation before opening a court case, but you can also begin it after a case has been filed. You can agree with the other party to mediate, or you can ask the judge to order mediation. While you're working with the mediator, your case will remain open, but no further court action will take place. You'll inform the judge about the progress of the mediation. In some courts, the court provides free mediation to help low-income parents work out parenting plans. Check to see if that is available in your court. Even if you can't reach agreement on everything, mediation is worth trying before going to trial. At the least, it'll help you to focus on issues you disagree on and help you reach agreements on some things, even if you can't agree on everything. A settlement conference is more formal than mediation. In a settlement conference, both people together meet with the judge before trial to explore ways to settle disagreements. If one or the other person has an attorney, the attorney will also attend. The judge provides options and can tell people whether their position is realistic if they go to trial. The judge may provide an opinion on what would likely happen at trial, but will not make any decisions or orders unless both parties agree. The judge may or may not be the same person who would decide your case at trial. You can usually decide whether you want the same judge as your trial judge or whether you want a different judge.
My experience has been, I've done many mediations and settlement conferences, is once you get to know the facts and you get realistic about it, there are only so many possible potential outcomes. And then it's just trying to pick the ones that is the most optimal and that's going to work for the long term.
In both mediation and settlement conferences, your statements, proposals, and offers are confidential. If you reach an agreement, only the agreement itself is part of the record. If you do not reach agreement, the other side cannot use the things you say during the mediation or settlement conference against you at trial. A trial is a formal court proceeding in which a case is heard in front of a judge. Evidence is presented, and a judge makes decisions. In family law cases, there is no jury. A trial is adversarial, that is, each side presents a position that may include arguing against the other side's position. When children are involved, it is almost always better if parents can find a way to work out parenting issues through an agreement in mediation or in a settlement conference, instead of having a full-blown trial where the judge makes the final custody decision. If you come to court to resolve your disputes, either property or custody disputes, the judge will try to do a very good job and listen to what you have to say. But the reality of the fact is that the judge will make a decision on the information that one side or the other presents. You know your children better than I will, or any judge will. You know your life better than we ever will. It's important that you try to work together to resolve your dispute.